Hello and welcome to the Rogers Brief for May 5th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to be covering mostly Nova Scotia news this week, and for those that don't watch regularly, I do often cover news from outside across the country and sometimes international news as well. This week I'm going to focus on Nova Scotia, and there's a couple of decisions that came out that I'll talk about, and some ongoing cases, new legislation, the Road Trails Act, which I'm covering on a special request of sorts, but it's an interesting new piece of legislation. I'll talk about that in a little bit. And I'm going to wrap up with a description of this this case out of Wentworth Valley involving a police officer. It was a very dangerous situation. Pike is the decision name. It's the accused of 11 different counts, including endangering the life of a police officer, break and enter, resisting arrest, dangerous driving, lots of charges there. So I'm going to close with that. It was pretty dramatic, very unusual situation. So I'll talk about that at some length towards the end. And I'm going to start off with just a note that today is May 5th. Tomorrow, the 6th, is the Coronation of King Charles. Hard to think of him sometimes. I sort of automatically still say Prince Charles, but King Charles. And what effect does this have on the courts? Well, it doesn't have an effect as of tomorrow, because the ascension of King Charles to the throne has already changed things in this way. Whenever court is opened or closed, it's God Save the Queen. It used to be, now it's God Save the King. And when you have court documents, everything is, it used to be the Queen, it would be, the Queen versus whoever. Or if you were suing the Crown, it was, whoever versus the Queen. Well, now that's the King. Lawyers who are advanced in years and have been given the honor of being Queen's Counsel are all now King's Counsel. So that's all made a change, and so unusual. People are still getting used to that. Every once in a while somebody will slip out the Queen, but it's King Charles throughout. All right, so that's happening tomorrow. I know lots of people will be watching the coronation. You'll have to get up early if you're interested in catching the whole thing here on the East Coast. I think 4 p.m. Either Eastern or Atlantic it starts. Okay, so that's a little fun stuff there. Into the news this week. Covered this last week. The Boundaries Commission, Federal Electoral Boundaries Commission for Nova Scotia, came back, dealt with some objections that were leveled by 3 Liberal MPs from Nova Scotia, 3 lawyers, former lawyers at least, lawyers that are now MPs, Lena Diab, Minister Sean Fraser, and Sydney Victoria MP Jaime Batiste. Come back in the news this week with Mr. Batiste. Jaime has announced that he's going to seek judicial review of the Commissioner's decision. The Commissioners decided that they were going to stick with the boundaries they had set, and they went through many of the reasons why they did so, including in that the whole consideration of the United Nations Declaration of the Rights of Indigenous Peoples Act that has passed the federal parliament but hasn't been enacted, in the sense that there's no plan in place. So anyway, they went through all of that in their decision. I covered that last week. Judicial review. So what is that? Judicial review is when an administrative body like a Human Rights Commission or Utility and Review Board or other administrative body that makes decisions, they make a decision, and then you can, if you don't like it, you can take it off to the courts. Well, this kind of a case doesn't have much of a chance of success at the court level. First of all, I guess, this isn't a legal consideration, but it will be a consideration of sorts, because you take that judicial review to the Supreme Court of Nova Scotia, and the judge will hear it. Well, they'll be reviewing a decision from the Boundaries Commission, but the chair of the Boundaries Commission is a judge of the Court of Appeal of Nova Scotia. So in effect, they would be reviewing a decision from a justice of a superior court. Further, if it went to judicial review and it was granted, or granted or not granted, and then appealed further, it would go off to the Court of Appeal of Nova Scotia. So Anyway, a bit of a circular round there through the judiciary, but more to the point, I don't think it will succeed at judicial review at all. I mean, the Boundaries Commission is they're experts at this sorts of thing. They do this every 10 years and they're independent. But also, they went through all the reasons why they did what they did and examined the legal basis for it very thoroughly. And, I just don't think there's any chance of that being overturned. There was some media coverage of this yesterday. CBC Cape Breton had a piece and Saltwire had a piece. Saltwire's piece wasn't attributed to any reporter, so I wondered if that was sort of more of a press release that was sort of regurgitated in the paper or not, but it wasn't. Anyway, it wasn't clear. The only one that's really got this right so far, or that's got to the real issue, is XFM, local radio station out of Anglican. And Anglican is now going to be included in the Cape Breton Anglican riding. And the current MP, Mike Kellaway, was interviewed and asked, well, what are you going to do? And because that hasn't been covered in any of the other stories, Mike Kellaway, the MP for Cape Breton Canso now, which covers most of rural Cape Breton, part of eastern mainland, said, well, I'll probably run in Sydney because that's where I live, Sydney Glace Bay. So that's the real issue. Now that's going to flip, and Batiste will have to try his hand at the more rural riding, which, as the Commission points out, has a greater concentration of Indigenous population than his current riding, which he's complaining to have to leave. So what is going on here? I think it's political considerations that XFM seems to have noticed and nobody else, and possibly a delay tactic. Judicial review takes some time. If there was an election held this fall, for example, I think we'd be still under the existing boundaries. But if it's anything into the spring of next year, then it would be under the new ones. Well, if there's judicial review taking place, perhaps Batiste would seek an injunction to prevent the new boundaries from being used. But two problems with that. First of all, you need to show, to get an injunction, you need to show that you have a decent chance of success, which he doesn't. And then secondly, you have to show that there would be irreparable harm if the new thing was to happen without being examined first. Well, there's no irreparable harm. You could have the new boundaries put in place, and then if it was overturned, then you could have the old boundaries, put back in place. And don't think you could show irreparable harm with that. So we'll see how that goes. Provincially, we saw this in Nova Scotia that the special seats for the African Nova Scotian population around Preston and the smaller Francophone Acadian seats were taken away and then reinstated. So if it was to be the case federally that they were reinstated, that could be done after the fact. All right, so those are the electoral boundaries. A couple of other things in the news this week. I see at the King's College this Wayne Hankey professor who died last February. King's College is being sued by one of the former students who alleges to have been abused by former professor and Anglican minister Wayne Hankey. So what's going on here? It says that in, I think, early 80s, Hankey he was mentoring, tutoring him one day and tried to reach into his gym shorts. Tried to, I guess, unsuccessfully, tried to reach towards his genitals. Not clear that this was reported at the time, but the student did leave King's, so obviously it had quite an impact on him. Now, King's, there was a report released not that long ago with King's acknowledging fault in these situations, and acknowledging that they were going to have to compensate some of the victims. So, okay, what's happening here that this is being made public? You can guarantee that there would be negotiations already ongoing in the background between, the victims and King's through their lawyers. And the only reason that we're hearing about this now is that those negotiations must not be going well for this particular victim. And he's represented by Wagner's, by a lawyer there, Liam O'Reilly. I don't know Liam O'Reilly, but I know Wagner's, and they wouldn't be taking on the cases if they weren't legitimate. It's a good firm. But the fact is, in this case, that negotiations must have not been succeeded. It must be too far away in numbers, and so Wagner should be using the courts and the media in this case to try to gain a little leverage and strengthen their negotiating position. So we'll see how that unfolds. The other case that was in the news this week was William Sandeson is back in the news. The almost med student who's convicted of murder, convicted a second time of murder. He was successful on an appeal the first time in, is appealing again, and appealing from, according to the news reports, a handwritten appeal from jail, which tells you really all you need to know about the strength of his appeal. Clearly does not have a lawyer hired for that. He's done it himself. The two grounds that he appears to be trying to use are that, if I'm reading between the lines a little bit, all right, so the evidence from the first trial, there was a private investigator that Sandeson hired that turned on him and gave some information to the police, which was used in the trial, and that invalidated the first conviction. I think he seems to be suggesting that some of that evidence was somehow brought in improperly into the second trial, so that may be an issue. But then also the second one is that charter rights, he claims, were violated by his text messages being used by the police. Well, he showed the police his text messages to try to throw them off the scent of saying, well, he didn't even meet with the victim, Taylor Sampson, that night. So I don't think he has much of a chance on that appeal, but that's, anyway, the courts will have to deal with that. All right, so next thing I want to talk about is this new legislation. There's some legislation passed in the spring session of the Nova Scotia Legislature, including the Road Trails Act. Now, the main thrust of this legislation is to have to allow off-highway vehicles, four-wheelers, side-by-sides, motorbikes to use parts of the road. If there's a trail that ends here and it connects, you have to use half a kilometer or something of the road to connect to the trail on the other side, well, you'll be allowed to do so under certain circumstances. Now, this was there was a pilot project that started in 2018 with 7 particular specific areas, pieces of road where that was allowed. Now, this act allows that to be expanded somewhat indefinitely. I mean, anywhere that the minister can designate as, any connecting points. So if anybody has trails that they use or would like to be using where, they connect to a road and you need to use part of the road, the province, and that is the Minister of Public Works, currently Kim Masland, who is the minister who spearheaded this legislation, can designate a highway or part of a highway as a road trail. And if something is a road trail, then it can be used by four-wheelers, side-by-sides, dirt bikes, off-highway vehicles, ATVs, and multi-purpose off-highway utility vehicles. So they can designate a road, but they can designate particular times for things to be used, can limit the time of day or the time of year, depending on the circumstances. So that's for provincial roads. If it's a municipal road, and so roads in Nova Scotia, I mean, there's the Trans-Canada Highway, but otherwise there's municipal roads and provincial roads. Most of them are provincial, even, but things within a town. Anyway, somebody will know. The Department of Highways, if you're thinking about trying to have something designated, just contact your local Department of Highways office and they'll be able to tell you whether it's provincial or municipal road. It's not always obvious. Sometimes there's agreements with the municipalities and the provinces to have the provinces plow and look after municipal roads, and there's financial arrangements there. So just because it's being plowed by a yellow truck doesn't mean it's a provincial road necessarily. Okay, but there's some rules here with this too. No controlled access highways, all right, so no major highways. And, it can limit the time of day. There's a lot of descriptive and prescriptive ways about how to drive on these things, all right? So maximum of 25 kilometers an hour, that's fine. You have to be licensed and have insurance and all those things, have a license plate on your rig. Can't have a learner's license. You have to have a left-hand side mirror. No modified mufflers. can't be towing another vehicle. No using the road trails. This is a big one. No using them at night, even if you have lights, proper operating lights. And there's a 30-minute leeway after sunset, before sunrise, where you can use them. But after that 30 minutes, you cannot use these trails. I think that's a big problem, actually. I don't know why that was put in place. There was in the broader general framework of the act, it allows time limits for time of day and time of year. But you could imagine some road trails, that's the only way home. And if you can't use it at night, then you're stuck in the woods at night, or you're stuck trying to sneak around. So I think that could be a problem. No passengers under 9 years old allowed at all on the roads. You have to drive on the shoulder where possible. And there's some other rules about making left turns and such, on how that's all supposed to work. So, but yeah, it's an interesting a good piece of legislation. Opens up a lot of possibilities for people to use the roads where trails have to connect. All right, so that's the Road Trails Act. If anybody's looking to have a piece of road designated, I think I'd start with the Department of Highways. They may point you to a municipality, and the municipality can do it by bylaw, so nothing very difficult there. All right, last thing I want to talk about is this case of the King versus Pike. Pike was it's not quite clear how it started. It was there was a car off the road, an old Toyota Corolla, and it starts at 6 in the morning, and this is in Wentworth. This gentleman's house, Cecil Vincent, 81 years old, upstairs, hears some noise in the lower part of the house, goes down and sees a guy there, didn't know him, with a hammer. And Vincent tells him, get out of my house, and he goes back upstairs. Comes back. He doesn't check to make sure he leaves, but he does. The guy leaves. Well, he's out on the road, and you see the car, the little Corolla's in the ditch, and this guy, Wayne Miller, neighbor, offers him a drive. Goes one way, goes another way, and brings him back to the vehicle, and offers then to help tow the vehicle out. Well, as he's doing this guy, who we assume is Pike, but I'll come back to that, says something to the effect of, well, gee, now that you've pulled me out, I wish I hadn't broken into your neighbor's house. And why he would have said that, this is in New Annan. Now, A-N-N-A-N. I'm not sure if that's New Annan or New Annan, if I'm pronouncing that correctly. So he mentions this, and Wayne Miller says, well, what are you doing? He wants nothing to do with him either. And he goes off to check on Cecil Vincent. He calls 911. Vincent is already called 911, or calling 911 around the same time. And so the police are alerted to it. Okay. Last thing Wayne Miller sees is the guy getting into a dark SUV or minivan and going down the road. Well, that we hear was later in the trial was Stephanie Dara, who was driving past, picked up a hitchhiker near this Corolla, and wanted to go. Wasn't sure if she could have gone either way to work, through Wentworth one or Tatamagouche one way or Truro the other way. Decides to go one way. The guy's like, well, actually, I wanted to go the other way. So as they're driving along, the police officer passes by at a speed, and Miss Dara says to this passenger, haha, what are they looking for you? Haha. And he's like, he didn't really say anything, and then he's like, well, maybe. And she's like, well, get out then. And she kicked him out of the vehicle. So, and he got out. So that was the second part, I guess, third encounter, but second element. And then we hear of these other gentlemen driving by. William Cameron is driving by in a Subaru Forester. He is looking for a place to go hiking in Wentworth, looking for a particular spot, so he's driving along kind of slowly. And then these other two, Isaac Elson and Silas Hubrick, are driving along together. They were going to church in Truro. Okay, they drive past this shirtless man. They drive past an officer stopped on the side of the road looking into the woods. And so then they drive past, yeah, they drive past the RCMP car. They drive past, this is Elson and Hubert, drive past the Subaru, which is going very slowly. And then they look in their rearview mirror and they see the police car cut off the Subaru and knock it into the ditch. So they turn around and come back. And this guy got out of the, got out of the police car, got into the back seat of the Subaru and says, all right, drive me. And Cameron in the Subaru says, well, I can't drive. We're in the ditch. We're hung up here and don't want anything to do with you anyway. Get out. So he gets out. This is Pike. Gets out and goes over to Elson and Hubert's vehicle. Says, want to get, give me a drive. And they're like, no, get out. And so he gets out. So, by the way, this is 5 times so far that the individual, who we now know to be Pike, was successfully shooed off by civilians. Well, this is, I'm reading through the decision, and the decision is from Justice Hunt out of Truro. Crown was Thomas Cater, and the defense lawyers Nicholas Hoehne, Hoehne, from Legal Aid. So we're hearing, this is the decision, and there was 11 counts in the decision. Well, we read all that, and then we hear the testimony, or we read about the testimony of Constable Trevor Gallen, longtime RCMP officer, who responded to the call, came very quickly, just within minutes. He stopped the suspect, who put his hand in his pocket and tried to show the officer that he had a gun. He seemed to be trying to do suicide by Mountie and try to get the officer to shoot him. Then that didn't work. Then he ran into the woods. And so he goes into the woods, Pike, and Gallen's looking for him. He goes a little ways away from the vehicle, and Pike circles back through the woods, sneaks back around and into the police car. Well, the keys were still in it. It was still running. The vehicle and the door was open. Gallen races back, fully geared up, and gets back just after Pike. Pike is in the car and putting the car in gear. Gallen tries to taser him. That doesn't work. Pike is reaching for his gun, so he's trying to stop him there, trying to get that to stop. He's in and out of the car. He's halfway into the car. He's reaching for the keys. His legs are out of the car. Pike takes off, rolling Gallen out of the vehicle, he thought he had a broken leg at the time. It ended up being deep tissue damage, very serious. He was off work for a month with the injuries, and of course to get a little psychological break as well. Half in and out of the car, Pike puts the car in gear, takes off, and then goes and rams the Subaru, presumably trying to ditch the vehicle, get the Subaru, and go undetected. Then Gallen gets a civilian vehicle, catches up to him, just around the bend, and arrests him. Manages to arrest him despite his injuries. Other officers show up not long afterwards. So pretty dramatic stuff there. So what was the charges? The charges were 11. There were 11 counts. Aggravated assault on Constable Gallen, theft of the car, theft of the RCMP car, resisting arrest, dangerous driving causing harm, dangerous driving, simple dangerous driving, escaping lawful custody, breaking and enter, that's at the Cecil Vincent home, possession of weapons for a dangerous purpose, that being the hammer, it was in his hand, breach, he was under, Pike was on house arrest at the time, and he had conditions to stay in his home, which was a Stellarton address, so he was quite a way away from home, probably an hour away. He breached his condition to keep the peace and be of good behavior, which is a standard condition on all such orders. And he was supposed to have a copy of his release conditions on him at all times, and he didn't have that. So breaches of all those. He was found guilty of 9 of those counts. He was found not guilty. The Justice Hunt found him not guilty of the new Annan offenses because none of the witnesses could really identify him clearly, could identify Pike. I mean, you put it all together and it seems to make sense, and the justice says this in his decision, but it has to be beyond a reasonable doubt, and that's a high standard. It's not just more likely than not. It's, you have to be quite certain. And, Vincent only saw the guy for a second. The second man, Miller, only saw him for, a minute as well. Didn't have a good look at him. He was wearing a hoodie, and, he was sort of looking ahead, driving, not looking to the side at the passenger. Same with Stephanie Dara. Didn't have a great look at him. You think that would connect the two incidents, but of course, logically it does, but not beyond a reasonable doubt in the view of Justice Hunt. So he was found guilty, though, of 9 of the events. I don't think the Crown could appeal on those 2 counts where he was found not guilty. I suspect that they won't because, of course, break and enter and possession of a weapon for dangerous purposes on their own are quite serious, but given the most serious elements of them are the later offenses with the officer involving Constable Gallen, then you don't think I wouldn't think that it's going to make a material difference to the sentence that's ultimately handed down to Mr. Pike. Sentencing is yet to come, by the way. Now, a couple of things. There's some of these charges are duplicates, like the dangerous driving and dangerous driving causing harm. Well, those are the same, the same acts. So you're not supposed to have 2 convictions for the same act in the same situation. So there's a case called Pineapple that articulates that principle. So counts 4 and 5, dangerous driving causing harm, dangerous driving, only one of those will stay. Probably counts 1 and 3, the aggravated assault on Constable Gallen and resisting arrest. You might suggest those are the same things, although different motivation. Well, anyway, resisting arrest will probably be the one that sticks. The aggravated assault may be dropped as a result of that. Anyway, we'll see what this guy. He was already on house arrest, so he must have something of a record, and probably a fairly serious one if he was on house arrest. That you don't get that for nothing. So I wouldn't be surprised if whatever sentence this guy gets is going to be certainly measured in years. So we'll see about that. Quite serious situation, and of course, added to it all, it was happening in the Wentworth area, not far from, where Gabriel Wortman conducted some of his killings throughout in April of 2020, near where Lillian Campbell was, but I have to check the geography there. All right, so those were some of the cases and news stories I thought would be interesting this week. I'll be back next week with another edition of the Rogers Brief. I'll be appearing again, I think, this Sunday night with Jordan Bonaparte and Paul Plango to talk more about the mass casualty report and some more elements of that. And otherwise, thank you for watching and thank you for listening, and we'll see you next time.